Welcome back to the video lecture on East Asian state leadership in international law. This time, we are going to talk about forced labor issues in Korea. The Korean Supreme Court's ruling on forced labor during the Japan's colonial period was a case in which victims who were de facto forcibly conscripted by the Japanese companies with Luz as a military producer brought a claim against the companies seeking compensatory damages for its illegal acts. The main issue of the case was whether the victims' claims rights has been extinguished by the 1965 Claims Agreement. Contrary to the findings of the law court, which rejected the plaintiff's claim on the ground that an identical suit had already been brought before the Japanese court, the Korean Supreme Court quashed over the law court's decision and remanded the case, holding that the Japanese court's ruling ran contrary to the spirit of our Constitution, and that victims' individual claims rights has not been extinguished by the 1965 Claims Agreement, thereby recognizing the liability of Japanese companies for compensatory damages. In accordance with the Supreme Court ruling, the law court, upon remand, awarded the plaintiff victims damages in the amount of the 100 million Korean won and 80 million Korean won respectively, recognizing the compensatory liability of the Japanese company. However, the Japanese companies refused to comply with the order, appealing the decision to the Supreme Court once again, upon which the Supreme Court dismissed the defendant's appeal and finally recognized the plaintiff's compensation. Despite such a ruling from the Supreme Court in Korea, the defendant's companies has refused to comply with the plaintiff's request for compensation. The plaintiff initiated enforcement proceedings, which in legal terms are liquidation, against the defendants to recover assets that they own in Korea. With regard to the enforcement proceeding litigation, the Daejeon District Court in Korea issued the order to sell the Mitsubishi Heavy Industries trademark and patent rights and to seize the shares of the P&R Company Limited, which is the joint venture established in Korea by Shinil-cheol and POSCO. The Korean government established a public-private council with a view to seeking a resolution to the forced labor issue, and subsequently submitted a statement to the Supreme Court opining that the liquidation process should be delayed, with the plaintiff having declared that they would no longer attend the meeting of the public-private council. It remains to be seen what kinds of solution the government would propose. The plaintiff representatives and the civic groups supporting them made thorough inquiry to the Ministry of Foreign Affairs regarding their right to diplomatic protection. The first, they inquired as to whether the government deemed forced labor during the colonial period as recognized by the 2018 Supreme Court ruling as an illegal act on the sole part of the Japanese companies or joint illegal acts of the Japanese government and the companies. And second, whether the government determined that the requirement establishing the Korean government diplomatic protection rights are not satisfied with regard to illegal acts of the forced labor, and third, if so, on what ground? The Ministry of Foreign Affairs Korea has yet to provide a detailed response. It is unlikely for the Ministry of Foreign Affairs not to know the answers to the aforementioned three inquiries. Then what would be the most appropriate response to resolve the issue from the perspective of the international law and diplomacy? From the end of 1952, the Korean and Japanese governments engaged in discussions on the normalization of diplomatic relations and post-war compensation issues. And on June 22, 1965, the Treaty on Basic Relations between Republic of Korea and Japan for normalization of diplomatic relations, so-called Korea-Japan Basic Relations Treaty, and its annexed agreements, that agreement between Republic of Korea and Japan concerning the settlement of problem in regard to property and claims and economic cooperation, in short, the claims agreement. Under the Korea-Japan's claims agreement, Japan agreed to provide Korea with $300 million in grants over a period of 10 years and the $200 million in loans, while confirming the problems of the claims are they completely and finally settled. According to agreed minute prepared during this process, the scope of the outline of claims of the Republic of Korea against Japan included the compensation of outstanding receivable of conscripted the Korean laborers, the claims for reimbursement of the compensation and other claims, and the claims of the Koreans against Japanese corporation or individuals. In other words, the Korean government included compensation for victims of the forced labor in negotiating the claims agreement with Japan. Accordingly, Japan's government has been claiming that all rights to claims of victims of forced labor have been extinguished under the claims agreement. The first public inquiry regarding the nature of the illegal acts of the Japanese companies is an inquiry in the forms of the question Arbiter Electric 1. The Supreme Court ruling in 2018 made it very clear that the forced labor during the colonial period was an illegal act, and that is an organized joint illegal act between the Japanese government and Japanese companies. It is too tenuous an argument to claim that the illegality of the forced labor during the colonial period, the found by the Supreme Court in its 2018 ruling, was an illegal act committed solely by the Japanese companies, independent of the Japanese government, on ground that the plaintiff limited the scope of dependence in their action for compensatory damages to Japanese companies without including the Japanese government as a dependent. Even if Korean Supreme Court issued an opinion interpreting the 1965 treaty, such a decision is effective only in Korea, without affecting the validity of a treaty concluded with Japan. As such, it is difficult to reach a compromise between the legality or illegality of Japanese colonization as claimed by Korea and illegality of forced labor as a corollary and the legality of colonization as contended by Japan. The 1965 Korea-Japan's Basic Treaty was concluded because there has been compromise without deciding the issues of the legality or illegality of the Japanese colonization. Hence, the oppositional perceptions of the Japanese colonial period on the part of Korea and Japan inherent in Korea-Japan's Basic Relation Treaty should be acknowledged as it is. The second and third public inquiries regarding the right to diplomatic protection are interrelated. The right to diplomatic protection is a right unique to the state, recognized under customary international law, that may be invoked in the event a state causes damage to the person or property of a national of another state, in which case the state of the injured national, the sick, they appropriate the relief from the former state through diplomatic or peaceful means. The state does not act on behalf of the national of that state, nor can a national claim or waive such a right. An injured state does not have the obligation to bring a claim on behalf of the injured national, and the right to diplomatic protection may be waived either on the part of states by occasions inferred from its conduct or by agreement. In determining whether the right to diplomatic protection should be exercised, the injured state takes into consideration its political and diplomatic influences with the injuring states based on its national interest. Regarding the exercise of the right to diplomatic protection, which is dispensary the act of the executive branch, the judicial branch of each state tends to refrain from judicial review, in that doing so may affect foreign policy. Among the criteria in determining the right to diplomatic protection, it is important to determine whether damages were incurred due to the illegal or unlawful acts in other states. Because the judgment of the judicial branch is binding on state institutions, it is clear that the plaintiff incurred damages from the illegal and unlawful acts of the Japanese government based on the judgments of the Korean Supreme Court. In other words, it is undisputed that the victims of the forced labor fall within the scope of the requirements of the Korean government's right to diplomatic protection. However, even if they are subject to diplomatic protection, whether the government must exercise the right of diplomatic protection is a separate issue. If the government of the injured state exercises diplomatic protection against the government of the injuring state to seek relief for the injury incurred by the nationals and receive the compensation through a lump sum agreement, the issue between two states would be resolved, with the only remaining issue being the domestic payment of compensation. Hence, there would no longer be any room to invoke diplomatic protection regarding the same issue. It would be reasonable to deem the issue between Korea and Japan resolved, considering that Korea has already received compensation for the damages incurred by the plaintiff victims through the lump sum agreement resulting from the exercise of the right to diplomatic protection. Therefore, the Korean government should sincerely apologize to the victims for failing to adequately address the issues regarding forced labor during the Japanese colonial period when engaging in the process of the normalizing diplomatic relations with Japan and concluding the claims agreement, and exert effort to reach agreements among domestic stakeholders on the matters at hand. The Korean government should present a specific roadmap, including policy alternatives for the prompt and adequate protection of all victims and just resolution of historical issues. Moreover, as a preemptive measure, it should provide compensatory damages in advance prior to the liquidation of the assets of the Japanese companies. Ultimately, the National Assembly should enact a special law providing advances payments of the compensation to the victims of the Japanese colonial period according to uniform and fair standard. Subsequently, it should devise a plan to implement various policies in support of the victims and their families by receiving trust from the Japanese government and partner companies in substantial amount through a diplomatic agreement. Should the liquidation of the company's assets proceed without implementing the foregoing measures, the Japanese government, in its capacity as a state of the injured companies, will have no choice but to exercise rights to diplomatic protection by claiming appropriate relief from Korea as the injuring states, inevitably leading to deterioration of the Korea-Japan relations. Thank you very much for your very kind attention.